I found it in the bottom drawer of my grandmother's file cabinet, tucked behind 4 years of tax returns. 3 pages, typed. A trust amendment, dated 3 weeks before she died. It removed all 4 grandchildren as beneficiaries. It gave everything to my mother. I read it twice, standing over the file cabinet. Then I sat down on the floor of my grandmother's home office, in the house she'd lived in for 47 years, and I read it a third time. The attorney who drafted it was not Howard, who had known my grandmother for 15 years. It was someone I'd never heard of, in an office 40 minutes away. My name is Haley. I'm 28, and what I found in that bottom drawer is the reason I know what undue influence means, what dementia does to legal capacity, and exactly what one judge decided had happened in my grandmother's living room 3 weeks before she took her last breath. Eleanor had one phrase she used about the trust that I've thought about many times since the amendment surfaced. She used it when I was in my early 20s, sitting in her kitchen, and she was explaining, unprompted, over coffee, the way she sometimes talked about things that mattered to her when the moment felt right, what she'd arranged and why. She said, "I've seen what happens when money goes back through the middle. It gets managed, it gets reallocated. By the time it reaches where it was meant to go, it doesn't look the same. I don't want that for you and your cousins." I asked her what she meant by managed. She said, "I mean decided for you by someone who loves you and thinks they know best." She trusted Howard with the document because Howard would have been the person in that sentence, the one who, if anything went sideways, would ask the hard questions, who would say, "Eleanor, is this what you actually want, or is this what someone has explained to you that you want?" He knew her well enough to tell the difference. He'd known her for 15 years. That's why he wasn't in the room 3 weeks before she died. His job was exactly to be the person who made certain things complicated. Eleanor was 81 years old when she died, 47 years in the same house, a garden she'd tended herself until the last 2 years, a kitchen where she made an apple cake every Thanksgiving that I have never been able to replicate despite having the recipe card in her own handwriting. She was, for most of her life, the sharpest person in any room she walked into. She remembered names, dates, the specific things each grandchild had mentioned in passing months earlier. She paid attention in a way that made you feel paid attention too. She had built her estate carefully. The house, a stock portfolio, a trust established a decade before her death that split everything equally among her 4 grandchildren, with my mother as trustee, but deliberately, explicitly not as a beneficiary. She'd told me this directly once over coffee at that kitchen table. "I want the grandkids taken care of, not funneled back through the middle generation." I remembered the exact phrase because it was blunter than she usually was. 11 months before she died, she was diagnosed with vascular dementia. The decline was faster than any of us expected. My mother moved in with her, took over her care full-time. Medications, appointments, daily management. The rest of us visited when we could. We were grateful to my mother for what she was doing. That gratitude is part of how this happened. I found the amendment on a Sunday afternoon 2 weeks after the funeral. My cousin Jade and I were sorting files for the estate administration, practical, necessary work, the kind you do when grief is still raw, but paperwork doesn't pause. I pulled the manila folder from the back of the bottom drawer, read the first paragraph, sat down on the floor. Jade asked what was wrong. I didn't answer immediately. I read the document again. Then I took my phone out and photographed every page before I touched anything else. The amendment was dated 3 weeks before Eleanor's death. That week, I knew it specifically because I'd visited that same week and left my cousin a voice note afterward. "Grandma seems significantly worse. She repeated herself 4 times in an hour. Couldn't remember I'd visited yesterday." I still have that voice note. The attorney who drafted the amendment was not Howard. Howard had been her attorney for 15 years, had drawn up the original trust, had known her well enough to vouch for her in any context. That attorney on this document had a different firm, a different town, 40 minutes away, a firm Eleanor had no prior relationship with. An attorney my mother arranged, not Eleanor. I called my mother that evening. I didn't accuse. I described the document and asked if she knew about it. She didn't deny it. She said Eleanor wanted to simplify things, wanted her daughter taken care of. She said she'd used a different attorney because Howard would have made it complicated. I stayed on that sentence for a long time after we hung up. Would had made it complicated. The family attorney who knew Eleanor for 15 years, the one who could have confirmed her capacity, who would have asked hard questions, who would have required time and independent confirmation, would have made it complicated. That's why he wasn't there. I called my 3 cousins one by one. Same reaction from each of them. Silence, then questions, then the same word, Howard. None of them had known the amendment existed. Not one. We hired an elder law attorney named Deborah within the week. I brought everything, Eleanor's full dementia diagnosis timeline, my visit notes, the voice note, a group text from that same week where I'd warned my cousins that Grandma seemed much worse, and the amendment itself. Deborah looked at everything. Then she said, "A trust amendment executed by someone with documented progressive dementia, drafted by an attorney with no prior relationship to the client, arranged by the person who stands to benefit, removing established beneficiaries. This is a textbook undue influence profile." She said it wouldn't be easy. She said nothing in probate is guaranteed. But she said, "The facts are strong. If the medical records support what your notes suggest about her capacity that week, this case is worth bringing." The medical records came back. Eleanor had been assessed by her physician 4 days before the amendment was signed. The cognitive scoring from that appointment placed her below the threshold that our state's case law requires for testamentary capacity on a document of this significance. 4 days before she signed. Deborah said, "We have the case."
My cousins and I had a specific conversation during the week before we decided to file that I've thought about many times since. Marcus, my cousin, Uncle Raymond's son, said something that settled the question for me. He said, "The issue isn't whether we win. The issue is whether we try. If we don't try, then whoever is in that room with whoever in this family is most vulnerable, with whatever attorney they've arranged, gets to change the document. That's the precedent if we do nothing." He wasn't talking about this case specifically anymore. He was talking about what it meant to let this pass without challenge, what it taught about what was possible, what it established about what would be tolerated. I said, "We try." He said, "Then we try." We called Deborah that afternoon. I want to be clear that I don't think every estate dispute should become a probate case. I don't think every family disagreement about an inheritance is worth the months and the cost and the exposure of a legal proceeding. But there are situations where the document was changed by someone who had no right to change it, under circumstances that removed the person's ability to make a genuinely independent choice, and where doing nothing is not neutrality, it is complicity. Eleanor had told me what she wanted. She'd told Howard. She'd put it in a document a decade earlier with clear, deliberate language, and none of that protected her in the end. The only thing left to protect her with was this. My mother hired her own attorney. Her position, Eleanor had experienced a period of lucidity that week, had expressed genuine wishes, had the capacity to make the change. Our position, a medical assessment from a physician 4 days prior said otherwise. An unfamiliar attorney arranged by the beneficiary said otherwise. The fact that no one else in the family had been told said otherwise. We let the judge decide. The hearing lasted 2 days. My mother testified, I testified. Deborah presented the medical records, the timing, the attorney relationship, the pattern. Then Eleanor's physician gave her assessment. She explained what the cognitive scores meant. She explained what those scores indicated about Eleanor's ability to understand a complex legal document and make an independent decision about its implications. The judge asked one question directly. Is it your professional opinion that on the date this amendment was signed, Eleanor had the capacity to make an informed, independent decision to substantially alter her estate plan? The physician said, no, it is not. The ruling came 3 weeks later. Amendment invalid. insufficient evidence of capacity at signing, suspicious circumstances surrounding document creation, original trust terms reinstated. My mother was not in the courtroom when the ruling was read. I don't know where she was. I know where I was, in a wood-paneled room with my 3 cousins, listening to a judge say that what my grandmother had written a decade earlier when she was fully herself was what would stand. I want to say something about the apple cake, because I've mentioned it twice now and I think it deserves a proper ending. The recipe is on a card in Eleanor's handwriting, her specific, small, neat handwriting that I've loved since I was a child. The card has a coffee ring on the corner, brown and permanent from some morning she made it years ago in her kitchen while the recipe was already memorized, and she was consulting the card the way you consult something familiar, not because you need it, but because it's there. I've made the cake twice. The first time was wrong in ways I could taste but not identify. The second time was closer, not right but close enough to feel like a direction rather than a failure. I keep the card in a small box on my kitchen counter, not because I need to see it every day, but because it's one of the things that was supposed to come to me from her, and it did. And the trust distribution was another thing, and the probate challenge was the mechanism that made sure both of those things actually arrived where she'd sent them. She wanted the grandkids taken care of, not funneled back through the middle generation. The trust document said it. The judge said it too, eventually. Howard would have said it in a hospital room 3 weeks before she died, if anyone had called him. Nobody called him. We got there anyway. The estate distributed 8 months after Eleanor's death, equal shares, 4 grandchildren, exactly as she'd intended. My relationship with my mother is different now. We speak, we see each other, but something has been placed between us that doesn't move, and we both know it's there, and neither of us has found the language to address it directly. She believes, I think, that she earned what she tried to take. 2 years of caregiving, daily sacrifice, the labor of watching her mother disappear. I don't dispute the sacrifice, I dispute the conclusion she drew from it. I have Eleanor's recipe box. The apple cake recipe is in it, written in her handwriting on a card with a coffee ring in the corner from some morning she made it years ago in her kitchen while the recipe was already memorized, and she was consulting the card the way you consult something familiar, not because you need it, but because it's there. Eleanor told me what she wanted, clearly years before she couldn't tell anyone anything. She told Howard she'd put it in a document a decade earlier with clear, deliberate language, and none of that protected her in the end. The only thing left to protect her with was this. Before I close, I want to tell you what Deborah said to me in our first meeting, because it's the most useful thing I can offer to anyone in a similar situation. She said, "The facts that matter most in an undue influence case are not the dramatic ones. They're the mundane, specific, documented facts, the date on the amendment, the date on the medical assessment, the name of the attorney who drafted it, the prior relationship or lack of one between that attorney and your grandmother. These are the things that either support the case or don't. The rest is narrative." She was right. What won the case was not the emotion, though the emotion was real and present in that courtroom. What won was 4 days. The medical assessment was 4 days before the signing. That gap, documented with the specific scoring that it contained, was the case. Eleanor kept records. She kept Howard's contact information in the same place for 15 years. She had the same attorney because she believed in continuity, in the value of being known over time, in the protection that comes from working with someone who has context. The amendment bypassed all of that continuity. It brought in someone with no context, no history, no relationship, someone who couldn't ask the questions Howard would have asked, who had no frame of reference for what Eleanor sounded like when she was herself. The judge noticed 4 days and a different attorney. Sometimes that's all it takes. Subscribe to Family Verdict for a new family betrayal story every week. If you've ever found something in a file cabinet that changed what you thought you knew about your family, tell me in the comments below. I'll see you in the next one.